This morning we have two gentlemen joining us to talk about this. We have legal practitioner Professor Joshua Olobo. He joins us from our Abuja studios. You're welcome to the program.
Thank you very much.
Right.
The pleasure is mine.
Yes, and we also have Adebayo Ojo, former Attorney General of Oyo State. He joins us on the program as well. Thank you so much for joining us on the program.
I'm glad to be here.
So, what we ask everybody, your initial thoughts on this judgment and the eventual sentencing of Nnamdi Kanu. We all knew the day was coming, but we didn't know, exactly what to expect. So what are your initial thoughts on it?
Well, let me thank you for having me. But I need to set the record straight away that I participated in the prosecution.
Yeah.
We were led by our leader, Chief Solomon Adeboyega Umalo, SCN, and also Mr. Suraj Saida, SCN. I'm the third lead counsel in that matter. Yes. You see, the case has a checkered history. It all started in 2015. One trial, 4 judges. 4 judges. In 2015, Nnamdi Kanu, the leader of the proscribed IPOB, was first arraigned before my Lord Honorable Justice Mohammed Ahmed.
Okay.
Now, a judge of the Court of Appeal. He was then in federal court. Barely at the matter taken off when Nnamdi Kanu objected and said he couldn't get justice from the judge court. And as expected, the judge returned the file to my Lord the CJN, Honorable Justice, to the CJ, as at that time, Honorable Justice Awuta. And the matter was reassigned to my Lord Justice So, who is now the Chief Judge of the Federal Court. He was then in Court 2. He started the matter. Nnamdi Kanu, in his habitual manner, also objected and challenged the impartiality or otherwise of the judge. That judge also recused himself and returned the case file. Then it became the lot of Honorable Justice Nyako to take up the matter. He filed a series of frivolous applications and several appeals, all to delay. And we must face fact and set the fact straight. All delays in that matter, till last Friday, were all at the instances of Nnamdi Kanu. In fact, he pursued an appeal from the Federal Court up to Supreme Court, which was right. He lost. He won in the Court of Appeal, which is what he was holding on to. Whereas he failed to inform people, and likewise his supporters and even his sympathizers, including some lawyers who have been mischievous. They failed to inform and enlighten people that there was appeal. And the Supreme Court set aside the decision of the Court of Appeal on that matter. And the Supreme Court ordered that remitted the case back to Justice Binta Nyako and said, my Lord Nyako should continue with the trial on those 7 counts. Supreme Court validated all those 7 counts charges and said they should continue. The trial was about to start when he came up with all series of applications again in his manner, until when he realized that he has reached a dead end, no trick for him to play again. And he also accused Justice Nyako of bias. Justice Nyako recused herself. Before Nyako again, he took several appeals again up to the Court of Appeal, which he lost 3 of them. Then Justice Nyako also returned the case back to the CJ. And it was signed to Honorable Omotosho, where it was. Let me say, Professor Osekume, SN was in this matter before. He withdrew from the matter. Likewise,
prosecution or defense?
No, defense for him. He was in the matter before. When the man could not go with his antics, the man, in order to save his integrity, withdrew from the case. Then we started before Honorable Justice James Omotosho. Then he was being defended by our leader, one of the respected counsel in the country, Kanu, saying, former Attorney General of the Federation, at a live venture. Chief Onyeka Piasu, one of the best too in the country, one of the 10-ton lawyers. Then Mr. Paul Elokuru was there. Anuge, SCN, Nkaso, Akarawe, the best anybody can parade. But unfortunately, and it's very important, which most people don't know, apparently with them, there are 4 gentlemen, who are gentlemen, in quote, lawyers too, who are also members of IPOB, IPOP. And I need to say, I must say, rather than taking objective, professional, and sincere legal advice from those top lawyers, the defendant prefer to listen to those 4 other lawyers who, when the other one withdrew, along with them, he retained those 4 lawyers as his consultant, legal consultant. You see, in this country, there are lawyers, we know ourselves. And the lawyers know themselves, we also know the judges. And believe me, you see, and criminal prosecution and defense is just like a lesser person would be say is sui generis, is also in a class of its own. If you are not an expert in criminal prosecution or criminal defense, better don't go there. Allow those who are well, fast, and trained. And I think Mr. Kanu had the best of lawyers in the Kanu Agabi-led team, which he chose to send away. So, you see, and again, I need to say this, all the issues that he raised before my Lord Omotosho had been raised and decided by the Supreme Court. Talk about, it was reported in the Blender, that's FRN and Kanu. Talk about the issue of extra rendition. It had been decided and pronounced upon. And the court said it will not feature the trial, no matter the way you are brought back to face your trial in Nigeria after you ran away. Then he raised the issue of that some laws were repealed. Supreme Court said no. The law is that the mere fact that a law or an act had been repealed does not mean that anything done under that law will go away, because there is always a what we call saving transition in any act, which will preserve what had been done under that law, and it will still go ahead. And Justice Omotosho clearly, pronouncedly, and profoundly pronounced on all those issues. So all the issues that he raised before Omotosho had been dealt with. And what do you expect? We just Omotosho now give a decision contrary to the decision of the Supreme Court. That will be judicial actuality. So we call 5 witnesses, PW1, PW2, 3, 4, 5, who tender evidences, who tender, apart from giving all evidences in the dock, also put before the court several exhibits, including video of his broadcast and interview. And he admitted, when he was being interviewed, that I made those broadcasts. You get my point? And through that broadcast, several lives were lost. And you know one thing, he took a gamble. No, as expected, he made a new case submission with the court overruled. The court overruled his next case submission. Then he was called upon to make defense. Then he started his habitual manners of delay and what have you again. You get my point? So then he filed several motions, repeating same issues that had been tried and pronounced upon by the Supreme Court. The judge severally dismissed those issues. All that, and you know, it is too elementary that in criminal trial, you can't stay proceeding.
Okay, anyway, there are a whole lot of stuff that have happened as far as this matter is concerned. And what we are getting now is a lot of feedback here and there. Now, you've just given us some background as to what happened from your own perspective. But let's also have a conversation with Prof in our Abuja studio. As you know, my colleague asked earlier, what are your initial thoughts about the entire proceeding? It took 10 years. There are those who are referencing the fact that the one that took place in the UK was done with in about a year. The one that took place in Finland was done with in about a year. But this one in Nigeria took 10 years. Does that imply anything in your own, from what you can see? Would you say justice has been served, or you think there are something? What are your thoughts?
First and foremost, we must appreciate the fact that the judiciary have risen to the occasion. And even the prosecuting agency, look at the matter that the United Nations House that was born 2012. The trials have just resumed, trial within trial. You see, the delay within the criminal jurisprudence actually create the uproar at the conviction of Kanu. Because if, for instance, our prosecution, which they have done their work hard, the judge has been firm and determined the matter timelessly, the issue will not arise, especially like some person like now, you know about Kabiru Sokoto, some other persons, Sunday Igboho, that agitated for Dual Republic and all those. Even in that judgment, my Lord Justice Omotosho acknowledged that Nnamdi Kanu was fighting for self-determination, which is his own constitutional right within the International Covenant of Peoples and Political Rights. We must appreciate that. That's what the court acknowledged. That even when he cited 1957 of Paul Enahoro, the court said that yes, that he's even getting to know about those particular situations. How about Macaulay was jailed because of his agitation for independence of Nigeria? So what I'm trying to say in essence is that there's nothing novel in this Nnamdi Kanu case. The only issue was the manner and the tactics employed by Kanu, which have actually generated a lot of sympathy, and law go beyond sympathy. Law is law, emotion is emotion. So first and foremost, we must commend my Lord Justice Omotosho for being firm, for being calm, emotional, intelligent, because if you look at what happened, especially during the judgment that was live televised, you know that I'm not surprised because I was part of Asai Dokubo in 2006, 2007, led by Festus Keyamo. That is the antics of freedom fighter. They can use words on judges. And it wasn't novel attitude. But the only issue in this case was that Nnamdi Kanu has the best lawyer, as my learned senior advocate have asserted. Right from before even Kanu Agabi came, Kazu is one of the best lawyer when it comes to criminal and election matters. Then you also recall that Michael Zokoma at the point was also his lawyer. And if you look at this judgment, before the no case submission was overruled, his lawyer participated in cross-examination of all the witnesses feeded by the prosecution. So now the issue, because some say that the court will have assigned him a lawyer since Section 1 sub 2 of the Terrorism Prevention Act 2013 has amended, carry capital offense. How do you provide a lawyer for someone that have area of senior advocate that have participated holistically? And he get to the point of defense, and he decided that he wants to conduct his defense by himself, which is within the realm of the constitutional right. Because Constitution Section 36 gives the latitude to any person to defend himself, either represented by a lawyer of his choice, or defend himself or represent himself. So, and even in my Lord Justice Omotosho also acknowledged that there were some lawyers that he called consultant, which is quite novel in a criminal jurisprudence. And the court allowed them, record their presence. At any given time, they were consulted, or there was conferences. So what I will say is that this is a wake-up call to Nigeria judiciary. Let's be firm. Heaven will not fall once any person is convicted. The only issue is that some feel that some person are above the law. The delay tactics employed, not only Kanu, even by order, because recall that this matter started 2001, not the 2015, because there was a fresh amendment. That was a child that was, after he was kidnapped, let me use the word kidnapped from Kenya. Then that was the basis of this particular matter. So I would not like to say from 2015 at the 12, even though some incident backdated to the acts from 2015, but this particular matter commenced in 2021. And that is why we must also look at the judgment. Even though the judgment, the court is under duty to give the mandatory sentence of death penalty, the court does not have discretionary power. One, there's a mandatory provision. But my law bend the law, just the human sympathy, quoting Matthew 23, verse 23, which will normally make as the alluticus. And he tempered justice with mercy. And I keep on saying, if Kanu one call lawyers go to appeal, and the prosecution appeal the sentence, he may even revert from life sentence to death by hanging. And also know that the life imprisonment does not mean that you'll be in prison throughout your lifetime. It's just a duration of 21 years. And that 21 years in the prison calendar, 9 to 10 months make a year. So it's less than 15 or 16 years. And also what the court did not have their mind in this judgment, section 416, sub 2, paragraph E, which is a sentence guidance that once you are convicting someone that has been in custody, the period of incarceration need to be factored, which means from that 2021 that he has been in the custody of DSS, that period have to read. But the judgment said that the sentence commenced from the 20th, which to me is a grave violation of the Administration of Criminal Justice Act. And although it can be remedied, because that period that he was incarcerated, isolated in DSS, the sentence ought to start from that day. That is 2021 when he was kidnapped.
So let me get this straight, Prof.
Well,
just 1 second.
From Kenya to Nigeria.
When you say that a life sentence is a maximum of 21 years, I want to understand. I thought life meant limitless till death do us part. Help me understand what you mean by it's just 21 years.
Yeah, that's the position of the Supreme Court. And as expert in criminal jurisprudence, the court has defined what constitutes life sentence. Life sentence is not that you're going to be there for life. It's a period of 21 years that constitutes life sentence within Nigeria criminal jurisprudence as decided by the plethora of cases by the Supreme Court.
Okay, let me ask the SAN here. Is that correct? So, or are you saying that it's just a placation, this life sentencing? Couldn't the Supreme Court, the court just have...
I studied, apart from law, criminology.
Okay.
And I also took criminology in my undergraduate years at the primary university in Ibadan. And I have not come to here or come and across any law which has fixed licenses to be 21 years. I'm surprised, but he's a learned professor. We keep on learning every day. So don't let us, we can go on with our subject of discussion rather than now, we must not argue our law here on TV.
Okay, now, Prof, let me come back to you very quickly. There are those who are referencing the substance of the issue, the political agitation, and the because it would seem like to a good number of people, it's an open and shut case. I mean, it's pretty much straightforward. There are those who are referencing on the one hand the right, which you also referenced, to self-agitation, the political agitations there. There are those who are saying that the issues of the Civil War have not really been resolved. Yet there are those who are saying that as a result of the pronouncements and activities of the convict now, Mazin Nnamdi Kanu, that there have been loss of lives and loss of economic activity, loss of property and all of that. And then there are those who are calling on the president's political intervention. In all of these, which one do you think takes the cake? Or do you think the only way to go about it is to continue in the judicial path?
The Supreme Court, even in a side document that I participated with Festus Keyamo, the current Minister of Aviation, denying Asari Dokubo Bay that one, national security is an issue, that individual right is on hold. So what I'm trying to say in essence is that court is court. Political question cannot be determined by court. It's at this time that I call on the political thought and the leaders of the Indigbo to arise above sentiment and employ the president to invoke Section 175 of the Constitution, because without conviction, they can't be pardoned. So even the judgment of Justice Omotosho is even in favor of the Kanu, with all sense of responsibility. And I dare say that the Deputy Speaker, Ben Kanu, and all those that feed that Igbo's party, that is Ebonyi now, that is in APC, Enugu has come to APC, Imo is in APC. If actually they are in APC for the good of the people, they should be able to sit the president down and say, yes, the sit-at-home order which violate the constitutional right of even the citizens of the Igbo, especially those that dwell in the southeast. Now the court has pronounced on it. A lot of people that are agitated on this judgment does not reside in southeast with all sense of responsibility. They are in Lagos, where they have a lot of freedom of expression. They don't know what people go through, how people suffer. Do you know, apart from Ahmed Gulag that died during the sit-home period of Monday, Justice Stanley Naji also was killed. So now the issue of self-determination and terrorism, how does it arrive? When you incite people or your message go ahead and, record that there's Eastern Security Network, which carry arms of the iPod, and record that iPod have been proscribed since 2017. There's no settlement about law. There's no settlement when it comes to law. Even like that, we're talking about whether, look, the problem of Nigeria is that we're not serious. As a people, since 2013, I did my master thesis on Boko Haram, threat to national security and right to life. But we were playing with Boko Haram to have a lot of franchise. In that same 2013, I did a comprehensive work on terrorism, kidnapping, and cybercrime in Nigeria, based on the invitation of the Benue Judiciary for me to present a paper on cybercrime. I can say with all sense of responsibility that Nigeria is not ready to fight insecurity. That is why the genocidal aspect is consuming. Not to say that Christian is being a victim. Every person, whether you are a pagan or you are in any religion, there is a genocide currently in Nigeria. And there's no need of differentiating whether it's banditry or kidnapper or any terrorist group. Once you carry arms and put people in a state of fear, that is terrorism. And it's quite clear. And the way the Northerner is pampering it, especially Gumi, we say that it's my people, that we need to look at the poverty line. This is what is creating disconnect. Okay. In as much as there's equality before the law, let it be in reality. All right. Well, look at what the Office of the National Security Advisor have been doing. No, Ribadu is my very good friend. Okay. All right, Prof. Thank you for those perspectives. Let me bring you to corruption in the rock. Just 1 second, Prof. Let me bring you to the SAN in our studio here. There are already readings of various other angles to the case. Some are saying, on the one hand, just as I told him, the accused or the convict, the person who has been convicted by the court, should appeal up onto the highest levels and all of those things, as is his constitutional right. Then there are those who are saying, well, we haven't really addressed, even though his methodology was faulty, the substance of what the issue was about hasn't really been discussed among the different stakeholders. There are those who are reading political permutations to it and all those things, and now calling for the president's intervention. What are your thoughts on that? And what will the implication of any of that be on judicial?
Let me first say this. Mazina de Kanu is a very lucky man. You know, under the law, which he faced, he underwent that trial. Once he's found to be guilty and convicted, the judge has told the discretion it will be their penalty. It is their penalty. Up to now, I'm confused as to what way in the minds of the judge to temper justice with mercy. Because for some offenses, a judge has no discretion once a defendant has been adjudged guilty. So it is their penalty, not life imprisonment. So the judge was very fair to him. And if he chooses to appeal now, the prosecutor too has the right to cross appeal on that issue of sentencing. And believe me, once his appeal fails, Supreme Court will now impose the appropriate penalty.
Yeah.
Yes, that's one thing. Okay, you are talking about the substance of his agitation. Believe me, your own right stop where my start. You must not exercise your own right to the detriment of my own right. Look, many lives were lost. Look, where did the Igbos, the people of the Southeast, where did they sit down and met and say, we appointed you, Nnamdi Kanu, to do this for us? No, he's only playing, insulting the intelligence of most people, exploiting the gullibles, and railroad them into his senseless, senseless, believe me. Did he command any military or any, what do they call it? What? Look, when the late Ojukwu embarked on civil, the late Ojukwu was a member of the military, trained even in England. Look at my point. You see, he has some command then under him, and despite that, what happened? What was the end of his agitation? It failed. But look, when this man embarked on this senseless agitation, many lives were lost. It was like him committing genocide even against the people of the Southeast. And if we are look at his disciple in Finland, Simon Ekpa. What happened there? He was sentenced to prison as well. Look, no agitation should lead to loss of lives. We must not shed innocent blood of anybody. And like we always quote the former president, Goodluck Jonathan, when he said, my ambition is not what it is life of anybody. Yeah. Look at the several people that he wasted their lives. It was even said that the husband of Professor Akuili was killed, was murdered by ESN in broad daylight. A man who was going about his lawful duties. What are we talking about, the substance? Which substance? Let's forget. If you have, we all have representatives in the Senate, we have in the National Assembly. If too late, let them take it up there, like Dr. Omotosho rightly advised him. Not that we now be incite people to kill others, to kill security agencies, to kill people, ask people not to go out. To me, it is meaningless. And I don't know why, how he was able to hypnotize some of his followers and people who agree with him until today. Some are still supporting such senseless to me. It is senseless, believe me. Let's forget about the substance. It's senseless.
Well, yeah, we're running out of time, but, you know, there are some of his supporters, you know, from the Southeast that seem to believe that he did not really commit any real crime. That real crime in quotes, because, I mean, he didn't do any action himself, but I would think that it's conspiracy.
Conspiracy?
It's conspiracy too, because he's the one that called. He didn't like commit the act himself, but he called for action for those acts to be committed.
No, under terrorism, under the Terrorism Act, incitement of people, incitement alone is enough. By any means. That act is comprehensive.
And even economic sabotage. They sit at home.
Yes, I agree with you. Look at Simon Ekpa now.
Yes.
Simon Ekpa did a full step here. Right. He was in Finland and he was making broadcasts. And he's facing the music now.
Yes, well, we are certainly out of time. Thank you, gentlemen, for coming on to the show today to talk about this. Senior Advocate of Nigeria, Adebayo Ojo, former Attorney General of Oyo State.
Thank you for having me.
Thank you.
Always a pleasure to be here.
And of course, from our Abuja studio, legal practitioner, Professor Joshua Anobo. Thank you so much for coming to talk about this issue.